Okay, hi, this is Heather Van Wild, Raindrop Works. Um, yeah, I'm honestly still kind of trying to play catch up with understanding a lot of what's going on here. I'll openly admit this is our first civil trial that we have covered. Oh, getting ready to start session.
We're here for day 5 in Erin Wenzel versus the City of Portland, case 20CV 37166. All of the same lawyers and parties are present. What do you all want to talk about before we get the jury in?
Your Honor, two items. One is Officers Bianchini and Officer Sanders and Officer Filippo were subpoenaed. In this case, counsel has indicated that he has released them from their subpoena.
Okay.
The defense may offer testimony by Officer Sanders, but otherwise the other officers will not be appearing. The second item my colleague may want to take up, and that's admission into evidence of the two videos shown to the jury yesterday.
Okay.
This is 11 and 12, Your Honor, and again, the city's information, the metadata indicates that these videos are outside the window that we've been talking about. They're from August 15th at approximately 12:33 a.m. and 12:41 a.m. So given the court's rulings that we're sticking to 9 p.m. to 11:40 p.m., we believe the exhibits, the two videos should not be admitted.
Okay. So I am going to admit the videos. And I will say so we had a conversation off the record, at least partly off the record yesterday, in which Mr. Burgess argued that Detective Kammerer opened the door to the RRT actions generally in the summer of 2020 based on the generality of the questions posed by Mr. Manlove, even after repeated clarifications by all lawyers through the course of this trial that the question or the testimony was being offered just for August 14th. I did not agree with Mr. Burgess that Detective Kammerer had clearly opened the door, but his testimony was, it was far-reaching, and so I think more evidence from that night is admissible given the breadth of his testimony and how he testified about what was actually happening and what officers were doing as a practice on that night. One of those videos, I think, is a City of Portland video, and I don't know where the other video came from, but it's clearly the same incident.
All right, Your Honor. Thank you very much.
And then 102, I'm not done with it. Some version of this document, I will admit, just in looking at it, there are entries that just involve a lot of speculation about what people in the crowd are about to do, and then there are repeated mentions of concern that they're heading to the Portland Police Association. So it's going to need to be redacted, and we can talk about that later. But
Sure.
Some version of this document will come in, and Mr. Burgess, I've circled things that I think need to be redacted, and I'm at some point we'll talk about what you think needs to be redacted if there's something beyond what I think does.
Your Honor, we came with multiple copies so everyone can work on redactions independently, and at this point, it's at least narrowed to the time frame.
Okay.
So I can pass those out. Besides 12.
You want me to just use a marker?
I
out the
have no
portions, or
idea,
would that-
but we will.
But then you wouldn't be able to see what's underneath it.
Yeah.
Highlights a good idea.
Or circle it in red.
So, what was
I
the
think that-
second video? So there was 112, and then what was the other video?
It was 12 and 11 were the two.
Okay.
I was just gonna, I don't know if the court wants me to, Detective Kammerer still has to do
Yeah, he's
potential
still
jury questions,
he's still
so
on
when
the
he gets up
stand.
there, I'll just offer the exhibits and then
Okay.
rest, or
Sure.
finish
You
with
can
the
do
witness.
that if you want. You don't need to. They're admitted.
Oh, okay.
I don't think the jury is keeping track of stuff like that.
Okay, I just, wanted to make
But
sure.
if you want to do it, that's fine. Are we ready?
I'm ready.
And we have, all right, we have detective camera. All right, detective camera, will you just come up and sit in the witness box, and we're going to swear you again because it's a new day. It is for us. I don't know if it is for you.
I think I'll do it when the one take care of you.
I take all,
Yeah.
take all the help I can get.
Yes.
I'm just, knock on wood, impressed that
Sure. Yeah, that would be great. Thank you.
5 days, 4 days without knocking anything over on any beverages over on the table. That's not like me.
Good morning. Please be seated. We're ready to continue with the rest of Detective Camera's testimony.
I'll swear you in. Thank you. Under the penalty of perjury, do you solemnly swear or affirm that the testimony you are about to give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Take a seat and please just state your name for the record.
Eric Kemmerer.
Mr. Burgess, do you have additional questions?
Oh, no, I don't have any other.
All right.
additional
Are there
questions.
juror questions for Detective Camera? Counsel?
I'm trying to, there we go, be mindful of volume because of how high up I've got the courtroom tuned. Yeah, I'm not entirely sure what's going on with the sidebar here when they already got all the stuff sorted out. Now, admit this case I have not gotten the chance to go into as
Okay.
oh.
All right, so Detective Kammer, I have lots of questions for you. If you know or can approximate, on August 14th, how many officers were present in Delta Squad on the evening in question?
I would just have to a rough guesstimate. We usually had about 12 line officers, 2 to 3 grenadiers, and then a couple of medics, and then the squad leader and the assistant squad leader.
And then just to sort of telescope out a little bit, how many officers do you think were there on August 14th from the rapid response team? I think we've heard that there were maybe 2 different teams there.
There were 2 squads, so we had 2 Portland Police Bureau squads, Delta Squad and Charlie Squad.
Do you know how many use of force incidents were reported by Delta Squad on August 14th at the rally?
Sorry, what was the last one?
At the event?
I do not.
Okay. And then on the day of the protest on August 14th, after the dispersal orders were given, were people walking away on the sidewalk, would they have been considered compliant by the rapid response team?
Yes. Yeah, I would say yes, generally yes.
Okay, and then under your policy or practice that night, would those people have been not touched by police officers?
I don't think that they would have been subject to force.
What, on August 14th, what made the assembly unlawful? Do you know why that call was made?
It was the incident commander's call. I can only assume, based on what I saw out there, that it had to do with the blocking of the streets, the refusal to open the streets, the establishment of the shield wall, and then the throwing of projectiles at the police.
Okay. I don't recall whether or not in your testimony you talked about someone walking away slowly in the street after a dispersal order on August 14th using a tactic to undermine the police. Did you give any testimony like that?
I do not recall if I did or not.
Okay. On that night, did you view protesters in the street walking slowly after the dispersal order had been given as engaging in a tactic to undermine the police?
On that specific evening, I do not recall specifically members of the crowd acting in that way.
Okay. You did see a video, though, from August 14th where police are in the street pursuing protesters who are in the street. So you have seen a video of people walking in the street away from the police after the dispersal order, right?
Yes, that's correct.
Okay. And would you say that the people you saw in the video from August 14th were using a tactic to sort of undermine the police, just based on that video?
Based on that video, yes, I would say that.
You talked about, as the squad leader, it was your duty to report uses of force. How could you, on August 14th, how could you feel confident in correctly capturing all of the incidents if you weren't personally there for each one?
So what we would do after we did a movement, when we would disengage, then I would pull the squad. Okay, who used force? What type of force did you use? And pushing, use of the baton in a push and not a strike or a jab, versus using the baton as a strike or a jab versus projectiles that were used or hand-tossed munitions that were used. And then I would create a tally of force usage from strikes and jabs up through munitions use and report that up the chain of command at the end of the evening.
Okay. Can you talk about the way that you would have viewed the Portland police use of force policy on August 14th? Under the policy, if someone verbally threatens an officer, is it acceptable under the use of force policy to push them? And if not, when, and if so, when under the policy?
So all force usage is contextual. So someone verbally threatening an officer does not necessarily mean that the officer is going to use force. That person would have to be capable of following through on their statements, and the officer would have to believe that this person was capable of doing so, and that the only way to mitigate this threat would be to use force to stop it.
Okay, and there's one more question. I'm not going to read it because the more I read it, the less I understand it. So I'm not going to read it. And now I'm going to ask Mr. Burgess, do you have follow-up questions based on the juror questions?
Yeah, Your Honor, just one moment. Based on your recollection of that evening, Detective Kammerer, you don't know whether force was used against people on the sidewalk or not, do you?
I do not.
Okay, so anything you would say about what the officers might be doing would be speculation?
Yes.
Okay. I think a few moments ago you testified that you believed that in the video protesters walking away from the dispersing and walking away were engaging in a tactic. First, I'd like to get some clarity on what video you're talking about.
So I'm recollecting the video of us moving through the shield wall, and then you see people kind of milling around. We're kind of moving through some of them and moving some of the others.
Okay, so you're not referring to the video that contains Ms. Wenzel in it? That of her walking away and being pushed by an officer from behind?
And I'm sorry, I don't know which video has Ms. Wenzel in it.
Okay. Can we show the? Would
Yes.
That be, okay, thank you, Erin. I believe. Talking about exhibit 2.
This is exhibit 14.
Or is it 14?
Um,
Yeah, you're right. It is 14. Thank
okay,
you.
okay, thanks.
Could you play exhibit 14? Well, sorry, before you play it, have you seen this video?
It's possible, sir.
Okay, that was a vague question. Do you recall if yesterday during your testimony you saw this video?
I saw a lot of videos yesterday. I don't remember if this is the one or not.
Fair enough. It was yesterday. Don't sweat it. I'll just play the video.
I do remember seeing this video now yesterday. Yes.
Now, okay. Do you see the sort of now lit up person in the middle with a green helmet and a respirator sort of mask thing on?
Yes. Yes.
Okay, and she's between two officers. So I want you to, I paused it because I want you to observe that person. And can you hit play? So after viewing that video, do you have any reason to believe that the subject that you saw in that video was engaging in some kind of tactic to slow the police's movement down the street?
The person in the green helmet?
Yeah.
There's such a short clip of the video with such a small window of that person being in there that I can't render an opinion whether or not that person was involved in a tactic of slowing the line.
Oh, thank you. And you'd agree that even if a person is engaging in such a tactic of slowing the line by walking slowly, that there would still be restraints under, or constraints under City of Portland policy in what type of force you could use against that person, right?
Absolutely.
Okay, you couldn't just hit them with a baton, with a strike, for example, for doing that, could you?
Merely for doing that, I would not think so, no.
Okay, and wouldn't you also agree that that you would not be permitted, under your understanding of the policies, to run at that person at full speed and hit them with a baton and knock them to the ground simply for doing slow walking in front of the police?
Your Honor, objections, provided that the question is limited to August 14th.
All right, Detective Camera, can you answer that question in the context of August 14th?
In the context of August 14th, I would not expect someone who's merely slow walking to have an officer run up at full speed behind them and deliver a baton strike.
Okay. And then you were asked a question about verbally threatening, whether that would warrant being shoved, I believe. And I think that's specifically a reference to what occurred in exhibits 11 and 12. Do you recall seeing those videos?
Are those the two videos of the person in the white shirt?
Yeah, on the bridge or near the bridge.
Yes, I do recall those.
You don't have any reason to know one way or the other whether that person verbally threatened or said anything to that officer, do you?
I do not.
Okay. And you can't see that in the video, right? From what you saw of it?
No, from what I saw, I can't tell what was going on there.
Okay. I didn't quite, so I heard you count up the number of officers in Delta Squadron as being around a dozen. Is that about right?
No, we would have been somewhere between 18 and 20 would be my best guess.
Okay. All right. And then how many in Charlie?
About the same.
So there would have been 36 to 40. Would that be an accurate range of the number of officers?
That would be a good approximation, yes.
Okay. And in each squad, there would be 3 to 4 grenadiers. Is that about right?
It depends on the personnel that were available that night. I'd have to actually see a roster for the evening to give you a definite answer on how many we had of each.
Okay. Was that a common, I think earlier in your testimony you said something about a few or a handful of grenadiers. Was that common?
Yeah, generally we had between 3 and 4.
Okay. And of the other officers, how many of them would have had either a short or a long baton?
So only the line officers would carry a baton.
Okay, and what is a line officer?
So you have the composition of an RRT squad. You have officers that form that line that you see that moves, and then the grenadiers are behind the line, and the squad leaders behind the line. So everybody that is on that line is a line officer, and they would carry a long baton.
I see. So would the majority of those officers have had either a long or a short baton that night?
Yes.
And you had an airplane?
Yes, there was an airplane that evening.
Okay. And there was a sound truck, is that right?
Yes.
And there was a sort of support vehicle with rails and handle sort of on the side to sort of ferry around the Delta squad or the Charlie squad.
Your objection,
Okay.
Your Honor. This is going beyond the scope of the jurors' questions.
Sustained.
Oh. You were also asked about the number of uses of force from that night. Isn't it true that there were a large number of uses of force that night?
I have no idea.
Would you be able to quantify it in terms of, were there more than 100?
No.
Were there more than 50?
No, I'm telling you, I would not be able to quantify it.
Okay, so it could be 100 for all you know.
I do not know the answer to your question, sir.
Okay. I don't have any other questions. Thank you.
No questions, Your Honor.
All right, thank you for your testimony, Detective Cameron. You can go ahead and step down.
Thank you.
Plaintiff calls Lieutenant Cheney.
Under the penalty of perjury, do you solemnly swear or affirm that the testimony you are about to give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please state and spell your full name for the record.
It's Franz Joseph Schaining, Franz. Middle name is Joseph, Joseph. Last name Schaining, Schoening.
Thank you. Lieutenant, how long have you been employed by the Portland Police Bureau?
Since January of 2002.
Okay. And you had your deposition taken in this case, and you were designated to respond on behalf of the city of Portland. Is that correct?
That is correct.
Okay. And back in August of 2020, you were the RRT commander, isn't that right?
I was.
Okay. And can you say what that means?
So the rapid response team is a team of folks who have normal jobs. They're patrol officers, detectives, whatnot, and then they volunteer for at a secondary detached assignment, the rapid response team. That team has administrative roles assigned to it. One of those is the team commander, which was myself for the summer of 2020. I would be responsible for personnel assignments, selections, procurement of equipment, that sort of stuff.
Okay. And you were not physically present on August 14, 2020 at the protest, is that correct?
I was not.
Okay. But were you on duty at the time?
I don't believe I was.
Okay. So did you have some kind of designee who acted on your behalf on that night?
No.
Okay. Who was sort of the highest ranking person present, do you know?
So you're talking a little bit about two different things.
Okay.
So
within the command structure, you're right, that was that question. Within the command structure of the RRT, who was, in terms of command, in command that night?
So I think one of the previous witnesses mentioned we use what's called the Incident Command System or National Incident Management System. It's basically a structured management system to manage complex events such as protests. On August 14th of 2020, I believe we were, based on my review of the documents I saw, we were using that system. There was an incident commander assigned to manage the overall event. And as I recall, that was Commander Craig Dobson.
Okay. And you have been present for the testimony in this case, correct?
I have.
Okay. And you heard the testimony of Ms. Wenzel, who testified earlier that while she was dispersing in the direction that the crowd was moving, an officer ran into her from behind and knocked her to the ground with a baton. Did you hear that testimony?
I did.
Okay. Based on what you heard of her testimony, is there anything about her conduct that in your mind warranted that level of force?
Based solely on her testimony?
Yes.
And no other information provided, I would say no.
Okay, thank you. And you saw a video that was put on by Ms. Collins, or that was testified to by Ms. Collins on Tuesday, I believe. And it shows protesters being moved down the street, dispersed down the street, and then you see a person, I think it's a woman, being abruptly shoved between two cars toward the sidewalk. Do you recall seeing that video?
Was that the video that had Officer Lehman and also Officer Taylor?
Yes.
Yes, I saw that video.
Was there anything in that video that you could observe that warranted that level of force?
I can't answer that question.
And why not?
So you want me to explain how I analyze the use of force under the Portland Police Bureau policy that existed at the time of August 14th, 2020?
No, what I'm saying is based purely on what you've observed, if that's all the information you have to go on, is what you see in the video. You didn't, for example, see that person throw projectiles at the police, did you, in the video?
I did not.
Okay, and you didn't see that protester that was shoved do anything other than just be in the street, isn't that right?
I did not.
Okay, and so just being in the street would not have warranted that level of force, correct?
Well, it's two different questions you're asking me. One is based on what I saw in the video. Can I make a determination of whether that use of force was within policy or not? And the answer is no, I can't. The video didn't provide sufficient information about what was going on for me to render a decision about whether that use of force is appropriate or not. If you're asking me the other question, which is simply standing in the street with no other information present, would that warrant that type of use of force? I would say it would tend to not warrant that type of use of force.
Right. And seeing that video, did it raise concerns in your mind that that use of force was inappropriate when you saw the video?
Again, you're asking me, I think, two different questions. One, you're asking me for an emotional response. And any use of force can be alarming. It can be disturbing. The emotional response is not necessarily applicable to an analysis of whether that use of force fits Portland Police Bureau policy or not. Again, the use of force in general is alarming. It can appear very disturbing, but at times it is lawful and appropriate under policy.
Right. What I'm saying is, seeing that use of force, it doesn't raise in your mind any concerns that it could have fallen outside of the city of Portland's policies, seeing what you saw?
Again, my response would be the video was disturbing. It was alarming. But do I have concerns, immediate concerns that it violated Portland Police Bureau policy? Not necessarily.
Okay. What about the video you saw, the two videos you saw yesterday from the bridge? You saw those exhibits 11 and 12, didn't you?
I did.
Okay. And same question. Seeing that video, those videos, did that raise any concerns in your mind that the use of force was not appropriate under the city of Portland's policies as they existed in August of 2020?
My response would be the same. The video did appear disturbing or alarming, but I can't say based on that video whether I'd have any concerns. I would not have any necessarily obvious concerns that it did violate policy. There's a lot of things happening that we don't see or hear in the video.
Right, but that's not even enough for you to look into it?
What? That's a different question.
Well, my question is usually when somebody sees a use of force and then, whose job it is to supervise and potentially initiate discipline against an employee, they would look at a video and then they would either say, this video doesn't rise to the level where I would think initiating an investigation would be appropriate, or it does. Seeing those two videos would either exhibit 10, which showed the push by Mr. Taylor, or the one on the bridge. Would either of those videos rise to the level where you would say, I need to initiate an investigation to figure out what happened here?
So generally, there's a couple of different ways. Well, I'll say this. On August 14th, 2020, there would have been a couple of different ways that a use of force would have come to our attention and would have been reviewed. First would be if an officer reports a use of force, they write a police report, a supervisor, not necessarily the squad supervisor, would review that police report and do what's called an after action. And that would be reviewed up the chain of command to determine whether or not the information contained in that document meets Portland Police Bureau policy or not. If it didn't, it would be referred to our Internal Affairs Division for an investigation. The other option would be if somebody witnesses a use of force or has force used on them or did on August 14th, 2020, they could file a complaint with the Department of the Independent Police Review. It's an outside entity that investigates complaints of use of force during protests. They would initiate an investigation. They would gather information based on that use of force, and that would probably include videos provided either by the complainant or that they found on the internet. And they would do that. They would interview the officer involved, interview the complainant, and they would make a determination on whether or not they believed that use of force was within or out of policy, and that would go through a findings process.
Right. And I understand that those are two avenues for initiating an investigation. But since you're the commander of these people, let's say you're in the field and you observed a use of force like that, you wouldn't be constrained to either, one, review that officer's use of force report, or two, wait for a civilian or someone else to make a complaint to the independent review, right?
It would depend.
You yourself could initiate a complaint or an investigation based on what you saw, right?
If I saw, based on what I saw, if I believe there was a policy violation, I would absolutely initiate a complaint.
Right.
And
So
report to internal
so
affairs.
it's not only reviewing the officer himself or herself, their own use of force report. You're not constrained by that, right?
No.
Okay, and neither would, for example, Detective Kammerer, who was present at this protest, right?
No.
In fact, any officer could initiate a complaint of that kind, right?
Yes.
Okay. And are you aware whether any such complaints were made on August 14 of 2020 by any officer in the RRT?
I don't know the answer to that.
Okay. You, when testifying on behalf of the city of Portland, you testified that that the city was not able to identify the officer that knocked Ms. Wenzel to the ground. Is that correct?
That is correct.
And you also testified that you can't, I think you testified that you weren't able to identify any officer that came into any physical contact with Ms. Wenzel. Is that correct?
Based on the documents I had reviewed at the time of my deposition, that is correct.
Okay, yes, and thank you for that clarification. And you also testified that the city is not aware of any witness to that physical contact other than Ms. Wenzel herself.
That is correct.
Okay. And you also testified that there was no other law enforcement agency participating in the protest in question in Northeast Portland at that protest on August 14, 2020, correct?
Based on the documents I reviewed, I had no reason to believe there was another law enforcement agency present.
Right. And the sort of combining those, isn't it the city of Portland's position and your position that if an officer came into contact with Ms. Wenzel at any time during that protest, that officer would have been a member of the RRT? Is that correct?
Sorry, can you repeat that again?
Right. Pardon, sorry, it's loading. If an officer came into contact with her or shoved her to the ground, as she alleges, it would have been an RRT officer that did that night.
I can't say definitively. I can say if an officer came into contact with Ms. Wenzel on August 14th between the hours that she was present at that event and was in the midst of that event, it would have likely been a rapid response team member.
Right, but, sorry, let me just. Your testimony, which is binding on behalf of the city of Portland, is that there were not any other law enforcement agencies involved in that protest, correct?
That is correct.
Okay. Pardon me, I'm having a little technical malfunction here. All right. As the commander of the RRT back in August of 2020, did you ever instruct your officers not to run into dispersing protesters and knock them to the ground? Did you ever specifically tell them not to do that?
Are we speaking about August 14th, 2020, or outside of the scope of August 14th, 2020?
Well, did you ever tell them that prior to that date?
We're talking about this on August 14th.
I was not working on August 14th, 2020, so I didn't have any conversations with members of the rapid response team.
Okay.
Actually, counsel, can you approach, please?
Yeah.
While we got a minute, I'm just gonna turn on the mic for this. Yeah, DOJ settlement, the settlement conference and that whole thing. I think that's where you're going, John. I don't know that there's really been any policy changes in specifically in the last 2 years. Because of that, I mean, I definitely could be wrong. I've had way too much on my plate outside of work, which is why I've been so absent lately. But, I think if there was,
Lieutenant, so you indicated in response to my last question that you were not present on August 14 of 2020, which I appreciate. But prior to August 14 of 2020, in the course of giving training or advising employees how to conduct crowd control measures prior to August 14 of 2020, did you ever tell them that you could shove a person with a baton from behind because they're not dispersing quickly enough?
No, I did not.
Okay. And did you ever tell them that they couldn't do that?
No, I did not.
Okay. Have you reviewed materials relating to what occurred that night, such as use of force reports, etc.?
I have.
Okay. Would you agree that that is, in fact, what happened that night on occasion?
Objection, vagueness.
Overruled.
Can you repeat the question, please?
Yeah. That on August 14 of 2020, after your review of use of force reports, that numerous uses of force included shoving by an officer of a protester from behind with a baton, sometimes knocking the person to the ground.
Yes, that did happen on August 14th, 2020.
Right. Numerous officers included that in their use of force reports, correct?
They did.
Okay, and none of those uses of force then led to any kind of discipline from August 14 of 2020, did it?
I can't answer that question.
Because you don't know.
Correct.
Thank you. Are you privy to any information about the accuracy of the use of force reports that were produced during the time period in which this protest occurred?
I am not.
You're not aware of any internal audits or reports by the city of Portland concerning the accuracy or completeness of use of force reports during protests at that time?
Well,
We'll gonna, limit it to August 14th?
Yes.
I may have, I can't remember honestly, if I reviewed any after actions related to the uses of force for August 14th, 2020. I may have.
So the master after action is a phrase that I've heard used now, and that refers to, in essence, the supervisor's review of the use of force reports to determine whether or not some kind of command counseling or instruction or discipline should be given in response, or an investigation initiated in response to those use of force reports. Is that correct? That was a terrible question, but if you want me to rephrase it, I will.
I think I got what you were asking. I guess my response would be you're conflating a number of different things.
Okay, please enlighten me.
So for August 14th, 2020, there was force used, there would have been force reported, there would have been an after action done that reviewed those uses of force. That would not be necessarily the master after action. The master after action tends to be a separate after action that looks at the overall event or events if it's multiple days. So the use of force after action would be a review, an internal administrative review of the use of force and whether we believed that it was within policy or not. If someone in that chain of review determines it is not in policy, they would refer that to our Internal Affairs Division for a full investigation.
Okay. And isn't it true that the master after action, first of all, did you review the master after action for August 14th of 2020?
I would have to look at the materials. I don't recall, but I could have.
Okay. And isn't it true that multiple officers were told, or that it indicated in the master after action that multiple officers had conflated passive resistance for physical resistance in their use of force reports by their own description of the event?
I don't recall that.
Could we have a sidebar, please?
Yes.
This is concerning me on a completely different level. The amount of I don't knows, I don't recalls from the commander of the RRT. You know, I mean, if I'm gonna be such a high profile witness because of my position, I would be like reviewing all of this stuff before I go testify so that I have the most accurate information. That's, it's the whole truth. I find myself asking the question of why there isn't, why he doesn't have like the number of uses of force, the number of them that were referred for investigation, I don't want to say that he's hiding something, but I can definitely see where his equivocation, for whatever reason, can make it seem like that's happening. In a way it does feel like that. And I mean, you can't take the fifth in a civil case, and he's not the one. He doesn't have any skin in the game. If the city loses, the city will pay the settlement, and then the police department will pay the city back. Well, and to muddying the case, yeah, that that's probably their best bet here because there's a lot of evidence stacking against them as to the behavior of the police. So if you can obscure stuff from the jury, that may help you look a little nicer.
So I am going to strike from the record the previous question about a document called an after action report. So if you took any notes about that, please cross it out and don't consider it in your deliberations. And at this point, we're just going to move on to a narrower version of the subject.
Thank you, Your Honor. Lieutenant, isn't it accurate that if a person is under City of Portland policies, as you understand it, if a person was, for example, remaining in the street after being ordered to disperse, that could not by itself give rise to a description or a characterization of, quote, physical resistance under the City of Portland's policies?
Are you talking about statically standing in the street?
Well, let's start with that,
Sure.
and then we'll go. So start with just standing in the street.
So standing in the street, refusing to disperse, following a dispersal order, and not moving at all would certainly constitute passive resistance.
Okay. And what about walking in the direction that they have been ordered to disperse without any, and so officers say you have to disperse, the person then begins walking and dispersing in that direction. Isn't it accurate that that isn't even passive resistance because it's not resistance at all, right?
That's a great question. And so the terms passive resistance, physical resistance, which tie to the Portland Police Board policy in place on August 14th, 2020, really are kind of a two-part question. Is the conduct active or not? And then part two is, what is the intent of the person engaged in the conduct? Do they intend to resist the officer's efforts to gain compliance or accomplish a governmental purpose? So I think we heard testimony that, that a lot of the folks out there on August 14th, 2020 were engaged in active conduct. There is a difference of perceptions about what their intent was, whether their intent was to comply with the dispersal order or the intent was to act in some manner that resisted the dispersal order. And that's where the rub is when you're trying to interpret intent, it's somewhat of a subjective evaluation based on what you're seeing, what you're thinking, all of those factors that we look at when we're analyzing use of force.
So in addition to the City of Portland's policies regarding the use of force, you agree that the City of Portland is also constrained by constitutional constraints on use of force, correct?
Yes, absolutely.
Okay. And isn't it accurate that under the Fourth Amendment, you cannot use more than trivial force on a person who is refusing to disperse?
Your Honor,
As you understand it.
Hold on a second.
first of all, it violates one of the court's pretrial rulings that we had on Monday with respect to the nature of the claims in this case. He's also asking him essentially a legal question.
Sure. So
If he-
you can ask him his understanding of the law that applies to use of force without describing the laws.
Right. Okay. You agree that you can't use more than non-trivial force against a person who is refusing to disperse, correct?
A person who is passively refusing a dispersal order,
Yes.
I would agree with that characterization.
So, is it your contention that if an officer subjectively believes that the reason that a person is not sprinting in their dispersal, but walking or not walking quite quickly enough, that means that they can regard it as physical resistance and use whatever force would be licensed by that characterization? Is that your testimony?
I'm not sure I understand your question.
Physical resistance under the City of Portland's use of force policies allows officers to use much more force than is allowed under passive resistance, correct?
I would not agree necessarily that that's what the Portland policy that was in place on August 14th, 2020 says.
Okay. If someone's engaging in passive resistance, the amount of force you can use against that person is less than the amount of force that you can use against a person who is engaging in physical resistance, correct?
I wouldn't necessarily agree with that characterization either, sir.
Can you explain why?
Sure. So when you're analyzing, well, let's talk about Portland Police Bureau policy. That was in place on August 14th, 2020. It attempts to synthesize some of the things you talked about, the Constitution, state laws around the use of force. And it additionally tries to provide some additional guidance based on the Portland Police Bureau's leadership, what their input is on how we do our job, the community's input, tries to capture some of that community expectation on how we interact with people, how we use force. So it adds additional constraints onto the use of force for certain things. Under Portland Police Bureau policy that was in place on August 14th, 2020, we're allowed to use physical force to accomplish a governmental objective. A dispersal would be something that we were trying to accomplish that was an exercise of our police powers when there was an unlawful assembly or riotous crowd, which I think is the question about August 14th, 2020. So we generally have an authority to use physical force. After you've established that legal authority, the question is how much force can you use and what type? Overall, it has to be objectively reasonable. It has to be necessary to accomplish what you're trying to do, which in this case was dispersing a crowd. When you do an analysis of whether that force was reasonable or not, it's based on the totality of the circumstances. It is all of the information that was present on August 14th, 2020. We heard a lot of testimony from a lot of different witnesses about all the things that were going on August 14th, 2020. So the officer who's applying force based on what they're seeing and perceiving and all the things going on around them, their decision on how much force to use has to be reasonable. Not only do they have to have a subjective belief that is necessary and reasonable, that subjective belief has to also stand up to kind of an objective analysis of their belief based on the information they're providing and everything else going on. So to the extent that you're saying that passive resistance necessarily is different than physical resistance, there are some constraints in terms of the types of tools we're allowed to use, but the overall amount of force is not necessarily tied neatly to whether it's passive resistance or physical resistance. It's more analyzed under whether it's objectively reasonable and necessary. Does that answer your question?
Well, I think it's sort of, it doesn't because it sort of sees the question backwards. Somebody engaging in physical resistance is a precursor determination that would have to be made in order to use certain levels of force, correct?
So again, the Portland Police Bureau policy that was in place on August 14th, 2020, places additional constraints that we've decided are appropriate, partly based on community expectations, partly based on attempts to synthesize, again, those other things you talked about. So for example, if you want to use an aerosol restraint, pepper spray, we do require physical resistance under the Portland Police Bureau policy. If you wanted to use impact munitions, there'd be other thresholds that we have said you have to meet to use those tools. For the general physical use of force, which pushing somebody would fall under, it has to be objectively reasonable and necessary. There are no additional constraints necessarily in place on that.
Right. A few minutes ago, I asked you whether or not a refusal to disperse was limited to nothing more than trivial uses of force, right? Do you recall that question and answer? And I think that your answer was yes, that you agreed with it.
I believe yes, generally speaking.
Okay. And so if a person is engaging, and I think you also characterized the refusal to disperse as passive resistance, is that also accurate?
I believe I characterize standing in the street statically, refusing to disperse as passive resistance.
Right.
Yes.
And you can't use deadly force against a person engaging in passive resistance, no matter what the totality of the circumstances, correct?
I would never say never, but I would generally say never.
Okay. And you can't, you wouldn't be entitled to shoot a person engaging in passive resistance, right?
I can't imagine a scenario where that would be possible or,
Right.
or allowed, no.
Okay. And so there, whereas if a person is engaging themselves in physical resistance and it would be, and there were, it was otherwise permissible under the totality of the circumstances, you might be able to. There are circumstances where you could imagine that happening, right?
Possibly, I would be hard pressed to think of a scenario, but it's possible.
Okay. My point is, there are different categories of force that are generally excluded from from being allowed to be used when a person is passively resisting, correct?
So again, I can speak to the Portland Police Bureau policy in place on August 14th, 2020. There are certain types of force that, again, we add additional thresholds to that include terms like physical resistance or active aggression. When you start getting into terms like, I think you said minimal use of force, or I forget the term you used, but that was a constitutional term, and I don't want to necessarily get into case law and constitutionality and how courts categorize force. I'm not comfortable doing that necessarily.
Right. So yeah, they don't use physical resistance is a term of art within the city of Portland's policies, right?
It's a definition, yes.
Right. It's a term you have defined in your policies.
Correct.
Okay. And I don't know if you actually defined physical resistance. Could you define that for me?
Physical resistance is a person's active efforts to resist a member's control that don't rise to the level of active aggression.
Okay. And so then just looking at the levels of resistance within the city of Portland's policies, at the bottom, I guess would be no resistance, compliance. Then there would be passive resistance, physical resistance, and then active aggression. Is that correct?
I don't think the Portland Police Bureau policy puts them at a ranked scale, but I would generally agree with your characterization.
Okay. I don't know if you recall from Mr. Taylor's testimony, but I asked him whether or not running at somebody at full speed and knocking them to the ground from behind with a baton was significant force. And I believe his testimony in response to that was that not as the city of Portland defines significant. Can you define what significant force consists in?
I would probably have to look at the policy. So the Portland Police Bureau policy on the use of force has a lot of definitions. It's a 20-page long policy that covers everything from, it's the policy that was in place on August 14th, 2020. It covers everything from what types of force are authorized, how force should be applied, how force should be reported, how force should be reviewed. So there's a lot of information in there. And so different components of that document use different definitions and different terms. I don't remember if significant use of force is the term or serious use of force. Sometimes those are conflated. But for certain types of force, whether it's force used that causes somebody to be admitted to the hospital, force that is used against children or medically fragile people, force used against mentally ill people or people in mental health crisis, or in some cases, I think force that involves multiple applications of a taser, meet the criteria threshold for what's called a serious use of force or significant use of force. I can't recall. And those types of force require notifications to different entities within the police bureau so they can take a look at it and make sure it comports with policy and other things.
Right. In fact, the phrase significant force is not a term of art that you've ever used. Is it?
Again, I'd have to look at the policy. I think it's serious use of force, but
right. So isn't it, I think what he's referring to, and you correct me if I'm wrong, but that deadly force characterizes any use of force likely to cause death or serious physical injury, including the use of a firearm, etc. I won't read the rest of it.
Objection as to what Officer Taylor thought on speculation.
Are you referring to
I'm not asking
A
about what
statement he
Mr.
made in court?
No, I'm asking about my question didn't even reference Mr. Taylor. My last question did. I'm asking him now whether or
Okay.
not serious physical injury is the phrase he was looking for.
I'm sorry, Your Honor, I may have misheard
Okay.
Mr. Burgess.
It's okay. Let me go back. Sorry. I believe you testified that you didn't think or you didn't know if significant force as a phrase has any defined meaning in the city of Portland's use of force policies. Is that right?
Yes, that is what I said.
Okay. And I said, isn't the phrase that I believe you were sort of defining is serious physical injury? Isn't that what you're referring to? And that deadly force is what would involve serious physical injury. Is that right?
I think I referred to it as a serious use of force,
Okay.
not a use of force that would cause serious injury.
Okay. Do you agree that running at a person from behind who doesn't see you coming and slamming into them with a baton held between your hands and knocking them to the ground forward is the kind of force that might injure somebody?
Yes,
Okay. Such as breaking bones, causing contusions, cuts, bruising, etc.
yes,
Emotional distress and trauma might also flow from such a use of force.
I would be speculating, but yes.
Okay. Do you think that simply needing to clear the street warrants a use of force at that level? That government interest by itself is sufficiently important enough to warrant a use of force like that?
Again, Your Honor, we're limited to August 14th.
On August 14th.
I'm going to sustain the objection, and then it sounds like it's calling for a legal conclusion to me.
Okay. On as of August 14 of 2020, did you have any concerns about the level of force that was being used by the police during protests under your command?
With respect, Your Honor, again,
With a baton.
You're asking me about,
Let me rephrase the question.
Sure.
Sorry, I was trying to address his
Sure.
concerns. I apologize. Did you have concerns prior to August 14 of 2020 about the baton usage by RRT officers during the protests in summer of 2020?
prior to August 14th, 2020.
Yes.
I had concerns about a lot of things, about how the protests were going on. Trying to answer this in a way that doesn't create issues. Dispersals of crowds that are engaged in riotous behavior or unlawful assemblies, where there's violence going on, where there are crimes being committed like arson, have to be addressed by the police. That's our obligation. It's our job to go out there and restore order to the community and prevent that sort of stuff from happening and getting worse. The ways in which we do that involve frequently the use of force. There are types of force that we use to disperse a crowd. Early in the summer of 2020, May, June, we used a lot of CS gas, tear gas. And we did that for a number of reasons. When you're going out with a group of 30, 40, 50, 60, 100 officers, and you're dealing with a crowd of thousands of people, your ability to use, hands-on force is fairly constrained. We used crowd control tools like tear gas, distraction devices, flashbangs, I guess the layman's term, impact munitions, those sorts of things, to try and get the crowd to stop doing what they're doing, that riotous behavior. The use of tear gas, although it certainly is concerning and was concerning to the community at the time, rightfully so. From a practitioner's perspective, is a fairly safe use of force. Tear gas is going to have a fairly temporary impact on the person. It's going to make it difficult for them to see, a little bit to breathe. It's going to basically create the incentive for them to leave the area and stop engaging in the behavior they were engaging in. Within a couple minutes, they're back to normal. There are no injuries that carry on from that. There's not, as you've pointed out, broken bones, scrapes, lacerations, concussions, that sort of stuff. So we prefer to use tools like that. As the summer went on, some of those tools were constrained based on community perceptions that we were using them too much, based on judicial rulings that we could only use them in certain situations. When you start removing those tools from our ability to disperse a crowd, we have to shift to other options. One of those options was the use of pushing people, shoving people, using batons on people, using impact munitions on people. Those types of force have a higher likelihood for creating injury. They also, for not only the people we're using them on, but also on the officers who are using them. Anytime you engage in a physical confrontation or physical fight with somebody, you risk injuring not only yourself, but also them. We had a lot of injuries of police officers
Your
during.
Honor, I believe this was addressed in a motion in limine.
The-
So I'm objecting.
So the
And
answer
this
is a little
non-response.
broader than the question. Why don't you just ask Officer Shanning to focus on your question?
Yeah, can we constrain your answer to address your specific concerns about baton usage, and not as and to be clear, I don't mean as a choice of tools among others. I mean about how officers under your command were actually using batons at the protest.
I guess to try and respond to that question, I have concerns anytime we have to use batons to push people or strike people.
Okay, but beyond your sort of generalized concerns about it as a tool or technique, did you have concerns that the use of batons, specifically of dynamics that would charge at a crowd and people are being knocked to the ground with batons from behind? I mean, this wasn't news to you at that time, was it? That was a technique that was being used and employed, right? I mean, you watched the news in July, didn't you?
I tried not to, sir. I was out there a lot. I guess I'm trying to understand your question. So did I have concerns that officers were engaging in misconduct? No.
And I didn't
not.
mean misconduct,
With
or I didn't
batons.
say misconduct,
Okay.
but but what I'm asking you is whether or not there was, I mean, I think you're defining misconduct to mean force that's being used when it shouldn't. Is that what you mean?
Yes.
Okay, so you didn't have any concerns that force was being used in circumstances where it was inappropriate?
Well, first, I'm not usually in a role where I was not in a role where I was reviewing the uses of force or investigating complaints about use of force. So I wasn't receiving information about allegations of misconduct involving the use of force. Is there another question there?
No, I don't. I think you've answered the question. So doesn't the city of Portland define misconduct as conduct by a member that violates Bureau regulations, orders, directives, or other standards of conduct required of city employees. Is that accurate?
That sounds familiar.
Okay. Based on your response to my last two questions, the officers that were running during a dynamic, holding long batons and knocking people to the street that were in the street, those people were not engaging in misconduct because they weren't contravening any directives, orders, or regulations that you had propounded at that by that time. Is that right?
We're talking about August 14th, Your Honor.
Yes.
Yes.
And my response would be, I don't know. If, first of all, I think we're, again, conflating some different terms. I think you've heard testimony, and I would echo that testimony, that the direction to move quickly from point A to point B to engage in a dynamic does not necessarily mean you're going to engage in a use of force. There were uses of force during those maneuvers, but it didn't necessarily mean by default you were going to use force. An officer who decides to apply force during a dynamic has to justify that individual application of force just as they would any other time. And there are a variety of reasons someone might apply force. One of those reasons would be to accomplish, again, that governmental purpose or exercise of police powers to disperse a crowd. It might be to arrest somebody. It might be to defend themselves or defend somebody else, which is also authorized under Bureau policy. So I don't have any information, and I did not have any information that on August 14th, 2020, any of those individual uses of force violated policy.
Well, my question was from August 14, 2020 and before that, because it has to do with your understanding of what training you were giving and orders you were giving. What I'm saying is, leading up to August 14 of 2020, you knew that officers were running in dynamics toward a dispersing crowd and were knocking people to the ground, didn't you?
So we're back to before August 14th, 2020.
Yes.
I knew there were uses of force that were going on during dispersals.
Right. And is simply being the last person in a crowd to disperse by itself a basis to be running into them with a baton and knocking them to the ground?
No, it is not.
Okay. But that was happening, right?
I wouldn't agree with that characterization.
Why not?
I haven't heard any evidence that someone was knocked to the ground solely for being the last person to disperse.
What evidence have you heard?
A lot.
Objection vague.
Sustained.
Hey. You seem to be referring specifically to something is my question. Are you referring to the officers' own accounts of their actions?
No, I'm trying to respond to your question, which
Well,
was the scenario, you posed a hypothetical scenario. If somebody is simply the slowest person during a dispersal, they're being knocked to the ground. No, I don't agree with that.
You don't agree that that happened? Or that you knew about it?
I have no information that that occurred.
As of August 14, 2020, right?
Yes.
Do you now?
No. We need a new question.
Okay. What do you do now?
Currently, I am the acting captain of the detective division, so I oversee all of our investigative specialty units: homicide, assault, robbery, family services, which includes domestic violence, child abuse. Yeah.
Okay. Just a moment, Your Honor. I have no further questions for this witness. Thank you.
All right.
Thank you, Lieutenant.
We can take a
Real
break
concern.
now unless the city's questioning will be brief.
I think it will be brief, but I think a break would be helpful.
Okay,
Use
all
the
right.
restroom.
So we'll go ahead and take our mid-morning break. Thank you. Be a 10-minute break that
Okay.
most certainly will end up being 15 minutes.
Thank you, you're, oh,
Okay, so, yeah, 10-15 minute break. That, I will admit that I'm not used to seeing lawyers, grilling cops in an attempt to point out their failings, because it's the first civil case that we've covered, as well as, you know, this is specifically a police brutality case. Yeah, that's kind of a good point there, Melissa. I mean, the whole thing with the Boise chief of police, who used to be the deputy police chief out here, and was only listening to ideas from fellow former Portland police officers that are now working in Boise. The special irony, before I moved out here, I spent good 5-6 years in the Boise area, so you know, I've had the Idaho and the Oregon side of things. I'll say I definitely prefer it over here. That said, I'm going to go ahead and go on to an intermission here myself. Take a few minutes, go get drinks, whatnot, and we'll see you back soon.
Rick, that with respect to the Bureau's use of tear gas or was
Objection previously excluded anything relating to this. All this
So, okay, so we're not gonna have any questions about the tear gas.
this, okay. I'm sorry, Your Honor, I thought this was something that he was discussing in his direct.
He was, but it was really beyond the scope of the question.
Okay, very, very good, thank you. Counsel had asked you, yes, I think the question was based on Ms. Wenzel's, the fact that you were here in court and you listened to testimony and seen some videos about August 14th, and based on her testimony alone, what she describes happened to her with this sort of first use of force that we've been talking about, this shove from behind while she's in the street, walking away from the officer. I think the question was, based on just those facts alone, would that force have been warranted? And I think your answer was, based on her testimony, no. Is that correct?
Yes.
Would it have been, to have a more informed answer, would it have been helpful to have had a video of the use of force that she describes?
Objection, absence of evidence is not lying.
Sustained.
Would it have been helpful to have other witnesses to the use of force?
Same objection.
Sustained.
Mr. Burgess asked you some questions about passive resistance and the Bureau's definition of passive resistance. So passive resistance is conduct that doesn't include violence against the officer, correct?
Correct.
And it's also passive resistance is something that doesn't include, quote, active conduct by the person, correct?
That is correct.
I think you said something about that. That's sort of where the rub is with respect to active conduct, correct?
Yeah, I believe so, yes.
In getting into, is the intent of the person to comply, or is the intent of the person to continue resisting the dispersal, correct?
Correct.
We've seen videos from August 14th. These two videos of the police Delta squad and perhaps other police officers moving against the shield wall. You saw those videos here because you were here in court, correct?
I did.
In your under the Bureau's policy, and is it your view that what the folks you saw in the video at the shield wall was that passive resistance?
Objection, relevance beyond the scope of the direct.
Overruled. You can answer.
Thank you, Your Honor. So, the challenge is, and it cuts both ways, right? When you're looking at a video, you don't have all of the information available to people who are out there, who are perceiving different things, who know different things. Those videos showed a lot of people. Within that group of people, there were people who probably were engaging in physical resistance. There may have been people engaging in passive resistance. So to the extent, that I can't characterize what every individual in that video is doing, and the determination that an officer makes when they're deciding to use force against an individual person is based on what they know and perceive in that moment, which does include some belief about whether that person's activity or actions, are intended to resist their efforts, assault them, what have you.
The police bureau's policies with respect to dispersal of crowds actually require, if feasible, that the bureau give announcements, correct?
That is correct.
And at least 2 announcements, correct, if possible?
Correct.
I mean, in your view, with respect to um, the appropriateness of a use of force, is the fact that warnings are given to the person, is that important?
That is one factor when you're looking at a use of force to decide whether it's objectively reasonable or not.
Is the fact that the person has time to comply with those warnings important?
Yes, it is.
And is the fact that the person has an opportunity to comply with those warnings important?
It is.
That's important all with respect to whether or not the force could be considered objectively reasonable, that once the officer makes physical contact with someone.
Yes.
I think Mr. Burgess asked you in the context, again, of someone dispersing in the street and, walking slowly. And again, we have a video of this from August 14th. I mean, you saw the video of Miss Wenzel after the immediate dispersal at the shield wall, where she was, I think council highlighted her, she was being moved along by a police officer. Do you recall the video I'm talking about?
I believe so.
And isn't it true that, depending on the circumstances, someone such as Miss Wenzel depicted in that video, I mean, isn't it possible that it could be interfering with the police achieving their governmental interests?
Objection calls for speculation.
Can you rephrase the question?
I'm trying to limit, my questions to the evidence about August 14th, and we do have we have several videos. We have the police video where the police van comes around the block, there's the dumpster fire, they pull up, there's the announcements, and then you see the police moving across the intersection. We have one video of the police making contact with the shield wall. We have actually another video showing the police at the shield wall where you can see the TriMet bus. And then there's a second video sort of later where we just talked about Miss Wenzel is depicted in that video, and she is physically touched and pushed by a police officer. My question is, based on those videos that you saw, and including, I guess, specifically the last video we have of this dispersal, based on those videos, can folks who are not on the sidewalk but in the street, can they, getting back to this intent, is it in your view that an officer could infer that that person's intent is to interfere with the police dispersal?
Same objection.
Sustained.
As a police officer, let me ask you this, based on your review of the of the videos and your presence in the trial, what was your understanding of the government interest that was trying to be achieved by the incident commander's declaration of an unlawful assembly?
Based solely on the videos?
The video and some of the testimony you've heard in court today.
So based on the records I reviewed for August 14th, 2020, based on the videos that were presented here, based on the testimony I heard from witnesses presented here, my understanding is that an unlawful assembly was declared because people were blocking traffic, they were lighting dumpsters on fire, they were throwing objects at the police, and otherwise engaging in criminal behavior that presented a clear and present danger of disturbance to the public.
And as I understand your testimony, you know, there's sort of two parts to the equation, right? With respect to any officer's use of force, but in particular on August 14th, there's the authority to take action and to accomplish that governmental interest, correct?
Correct.
And that's what you just described with respect to your understanding of the declaration of the unlawful assembly, correct?
Correct.
And then it's true that the manner in which that authority is carried out has to be objectively reasonable, correct?
That is correct.
With respect to the use of force.
Yes.
And is it the Bureau policy that reasonable force is only that which is necessary to accomplish the official police purpose?
Yes.
Do you recall Ms. Wenzel's testimony that, again, with respect to the first use of force that Mr. Burgess was asking you about, that the officer ran by her to some sort of larger group of protesters in front of her?
I do recall that.
Sorry, objection relevant, that was,
Oh, yeah.
he asking if he's heard testimony and then has no follow-up.
Is that part of the I'll wait for the ruling, I'm sorry.
I rule. You can continue.
Is that part of the context of Ms. Wenzel's own description of that first use of force that happened against her?
Yes.
You said that with respect to, there's some questions about misconduct and receiving information. There are other parts of the City of Portland's Police Bureau that receives that type of information, correct?
Not only the police bureau, but also the independent police review.
Right, and I think you described sort of the different sources of that, allegations of misconduct that would get to those people, correct?
Yes.
You know, whether that's from police officers themselves, the community members, watching, or the complainant who is complaining about the use of force. Is that correct?
That's correct.
There was a juror question earlier this morning with respect to, I think, the number of uses of force on August 14th. And as part of your, you were the city's witness for Mr. Burgess and Ms. Wenzel's case against the city, and you had your deposition in May. So as part of preparing for that deposition, did you review the use of force reports from August 14th?
Yes, I did.
Do they, and to try to answer this particular juror's question, do you know how many officers wrote uses of force reports?
If I recall correctly, there was about 24 officers that reported using force on August 14th, 2020.
Well, the 24 officers that wrote use of force reports, correct?
Correct.
And is it true that within that use of force report, would the officer document different incidents of uses of force?
Yes.
Do you see what I'm asking you?
There can be multiple uses of force reported within one force report.
And I guess, do you know the answer to the juror's question about how many different uses of force were documented?
I do not, I'm sorry.
But we have 24 officers reporting force.
Approximately, yes.
And that reported force included pushing people with batons, correct?
Yes, among those 24, there were reports of pushing people with batons.
And of those 24 officers, they reported pushing people with batons to the ground, correct?
There were some, yes.
And there were, of those 24, there were at least a few reporting striking people with batons, correct?
I believe there was one that reported striking somebody with a baton.
And again, one of the topics for your deposition in May was, if you were able to identify the particular officer that, or I guess the two officers, because we have two uses of force at issue in this case, if you were able to identify either of those officers.
Hold on a second. Can you approach, please?
Not sure why the city is trying to identify the officer when they've one of the problems with this case was they were never able to identify the officer. That this is kind of confusing, but and also I didn't realize that my mic was on this whole time. I apologize about that, but. Oh, you actually heard squeaks? The funny part is she's actually deaf. But apparently deaf cats can be very vocal because they can feel the vibrations and the echoes, so they like that. Luckily, I was more working on 3D printing stuff than typing, so. Anyway, I think we're. What? Okay, going back.
Earlier this morning, Mr. Burgess, he was talking about what your role at this deposition and, whether you were able to identify the two officers involved in the two uses of force that Ms. Wenzel has, brought before this jury for them to evaluate. In looking at the FDCRs, these use of force reports for these 24 officers, were you able to make such an identification?
I was not.
Nothing further, Your Honor.
Redirect?
Yes, thank you. You were asked earlier about characterizing the level of resistance from the individuals that were immediately behind the shield wall. Do you recall being asked that question by Mr. Manlove?
No, sir. I think I was asked to characterize the behavior of everybody in that video near the shield wall.
Okay, that's fair. And I believe your testimony was that you thought that there may be people engaging in physical resistance and some engaging in passive resistance, and that you couldn't exactly say one way or the other. Is that correct?
I think the primary point of my testimony was that I couldn't characterize necessarily the behavior. There probably was people engaged in physical resistance based on the video of the shield wall, but there could have been people engaged in passive resistance also in the video.
Okay, thank you. And I just want to be clear about what the effect of, you were also asked about whether warnings were given, or, and I think there's been multiple videos shown that there was a vehicle with a loudspeaker that projected orders to disperse to the crowd. Is that right?
Yes.
Okay. And the giving of that warning by itself does not give license for the officers to then engage in any use of force that they want, simply because a dispersal order was given, right?
No, that's just one piece among many factors.
Right. And so whether or not an order to disperse was given isn't going to tell you in any specific case that means this use of force was justified or not, right?
Sorry, I want to make sure.
You can't rely on that alone to justify use of force, correct?
No, I wouldn't rely on any one piece of information alone, whatever it is, to justify use of force.
Including an order to disperse from a loudspeaker attached to a vehicle.
Correct.
Thank you. I think earlier you testified in response to a question about what officers might perceive, what they know. It's not your position that an officer can predictively say, I think that person might go do X, therefore I get to use Y level of force against that person, right? You don't get to assume what they might do in the future as a basis for applying force, do you?
I would disagree, sir.
Okay. Isn't it true that the city of Portland has been ordered to not do that?
I would disagree, sir.
Okay. So isn't it true that a federal court in one of its orders regarding the use of force during protests told the city of Portland that it could not, for example, use force against people simply because it thinks they might do something in the future? Isn't that part of it?
Objection, Your Honor.
What's the basis of the objection?
Counsel is referring to an order that doesn't have anything to do with August 14th or the use of batons.
Then the objection is sustained,
Okay. May I be heard, Your Honor?
but not in front of the jury.
Okay. All right, I'll
You
just
can come
move on.
talk to me if you want.
Okay. I'll withdraw that question and ask it, hopefully a better one. If an officer observes, is that, let's say, on August 14 of 2020, is dispersing the crowd and they observe a person in the street in front of them dispersing, that officer wouldn't be able to say, I bet that person is going to run around the block and come set a dumpster on fire, so I get to go run up against that person and knock him down with a baton, right? That wouldn't be a permitted inference by an officer.
I would agree with that statement.
Okay, thank you. You reviewed, Counselor asked you if you reviewed the list of the uses of force that were applied that night. Do you recall that question and answer?
I do.
Okay. I don't have a physical copy of my of all of the discovery in this case, but I do have it on my computer. May I approach the witness, Your Honor? Okay. Please forgive the 30 tabs that are open. But so if you could just scroll through these pages here. I'm sorry, Bill. Do you want to take a look? Yeah. Here. Well, that actually. This is the list. It's not anything that I just use. Okay. So, if you could, gonna knock something over here, sorry. If you could just take a look and scroll through from page 204 here to 209. Could you do that?
I can try.
Okay. If you need any assistance, please let me know. Okay. So,
You want me to go through the entire document?
no, I mean, if you could look, just sort of glance through it. Is that part of the documents that you reviewed did those documents form part of the review that you were asked about by Mr. Manlove?
Counsel, just so we're clear, you wanted him to review pages 204 to 209, correct?
Correct.
Okay. So that's what he's asking you to review.
To answer your first question, I don't recall whether I reviewed the after action for August 14th, 2020 as part of that set of documents I reviewed. I specifically remember reviewing the individual force reports. I may have looked at this document. I don't know.
Okay. The after action lists out by officer all of the uses of force that were documented from that evening, correct?
It should.
Okay. And correct me if I'm wrong, but it looks to me like there are 26 or so uses of force listed per page. Is that right?
I guess first I'm looking at pages 204 through
209.
209. I don't see dates on pages 204 through 209. So,
Well, we can get to that in a second.
Okay,
Let's
see.
I've
So,
only been provided documents relating to that date, so I think we can safely move under that assumption. But if you can look through that and tell me whether or not this refreshes your recollection as to the number of uses of force from that evening.
and you had a specific question about how many per page?
Yeah, I think it's about 26, depending on the page.
It appears to be 18 on page 204. About 26 on page 205. Yeah, so I would agree with your characterization. There's on most pages there's about 26.
Right. So if there's 6 pages, we're looking at somewhere in the range of 150 or so uses of force from that evening that are documented that were documented that night.
The objection, Your Honor. May I, again, I think the question should be, it's not specific enough. This case is about the use of the baton.
You want the specific number?
No.
Okay.
It's our case is limited to the use of a baton. This document has perhaps other stuff in it.
Right, but you asked him whether he reviewed all the uses of force from that evening. I'm asking him how many there were.
So, okay, so we've had the information about how many.
That's fine, Your Honor. This is in response to the juror's question, so that's fine. I would withdraw the objection.
So
Would
am I-
you
am I
agree
still
that it's around
answering?
maybe 150 to 100 in that range?
I would need a calculator. The first page only has about 16. The last page only has 3 uses of force, so I don't know how many pages. I mean, if you're just talking ballpark math, I can't disagree with your characterization, but I don't know.
Maybe it's closer to 125.
Sure.
Okay, thank you. When you acted on behalf of the city of Portland to discern whether it was possible to identify the person that attacked Ms. Wenzel, did you interview any officer?
I did not.
Did you show Ms. Wenzel's photograph to any officer who was there?
I did not.
Did you review any footage from the city that was produced either by the plaintiff or that was obtained by the city of Portland from that night?
I may have.
You don't know, though.
I don't know if that was, I don't know.
Is it, did you show videos to the officers, for example, the one that we saw earlier with Ms. Wenzel in it, did you show them a video with her and say, do you recognize this person? Did you use any force against this person to any of the officers from that night?
I did not.
Did you limit your search to only documented uses of force that involved a baton?
Well, my understanding of Ms. Wenzel's allegations was that it involved a shove with a baton or a strike with a baton. The documents I reviewed probably did contain other types of use of force, but I was most closely looking at whether any of those uses of force with a baton or a shove with a baton lined up with the information I had about her allegations at the time.
I see. And you fixed my bad question. What I meant to ask was whether or not you confined your search to reports of uses of force that were labeled as being a baton strike or anything like that, or did you just review all of the use of force documentation?
I guess I don't understand that question. Can you?
Okay, I'll ask a question to aid in clarifying.
Thank you.
Some of these uses of force are documented as a baton or involve specifically referencing a baton in the labeling of the use of force, correct?
Yes.
Like it will say baton and then it will say strike or another descriptor, correct?
Yes.
What I'm asking is whether or not when you looked into it, did you search by label or did you review all of the use of force narratives?
I looked at all of the reports of force from that night. Certain types of force would be more likely to match the description of what I knew to be at the time Ms. Wenzel's allegations. Those could involve a baton strike. They could involve a control against resistance, which may include the use of a baton. So I also reviewed those very closely. But I would say I did a cursory examination of all the FDCRs.
Okay. And isn't it true that many of the, and you said FDCRs?
Sorry. Force Data Collection Reports.
Okay. And when those reports, many of them describe, for example, applied force against 4 people for doing something of that nature, right? That they're not all one narrative, one person, right? That against whom a force is used, right?
Want me to explain how an FDCR looks or how it's drafted?
Let me ask a better question. Inside of an FDCR, there will be a descriptor of a use of force, and those uses of force are not always specific in terms of their description of who the person is that's being pushed or struck with a baton.
So the force data collection reports are designed to capture as much information as the officer can provide about the use of force. Each use of force application, whether it's one person having force used on them multiple times or different people having force used on them by the same officer, the description of those force incidents would be within that officer's force data collection report. It's limited to what the officer perceived at the time and could remember at the time. So, we heard a lot of testimony about this incident being from all the different parties, being fairly violent and chaotic. There were, as counsel, indicated, there were a lot of uses of force. So when the officer drafted their force data collection report, they would put as much information as they could into that description of that incident, including whether they could identify the person and associate that with a person's name and date of birth, et cetera. Again, we heard testimony that a lot of the folks engaged in protesting that night were wearing helmets, respirators, black clothes. They all looked fairly similar. We also heard that officers were dressed fairly similarly. So to the extent that a police officer couldn't identify a person by name or date of birth or vice versa is not surprising to me. So does that answer your question, counsel?
Yeah, I think it does. Isn't it accurate that the Portland Police Bureau has had issues with the accuracy and fullness of its implementation or use of force data collection reports in the past?
Objection relevance.
Let me rephrase that. As in or on August 14 of 2020, at that point, isn't it true that the city of Portland Police Bureau, that is, was not maintaining accurate records of its force data collection reports?
I didn't see any issues other than the general difficulty being specific about the exact description or timing of a force incident to say that there were issues on August 14th, 2020 with the force data collection reports.
And by that, I assume what you mean is that you didn't, while you were observing the force data collection reports from that night, you didn't see anything problematic about those reports themselves.
That's correct.
Right. But isn't the concern that not all I'll withdraw that question. You were present when Brent Taylor was on the stand, correct?
I was.
Okay, and he testified about a use of force that was contained in Exhibit 10. Do you recall? I think it's 10. The woman who's standing between the cars, who is shoved by Officer Taylor. Do you recall that exhibit?
So.
Okay. And when I asked him about that exhibit, I showed him one of his force data collection reports to refresh his recollection. Do you recall that?
I can't say for sure.
Okay, fair enough. But I did, I asked him whether or not the report that I was showing him corresponded to the incident in question, and he said that it didn't. And I asked him if there was some other use of force report other than the ones he had put into the Portland Police Bureau database, or whatever you call the place where you store FDCRs. And he said that he couldn't say. And when I asked him whether or not he documented all of his uses of force, I believe his answer was that he couldn't say whether one way or the other, whether he did. Did you speak with any of the officers from that night to see whether or not there were uses of force that they didn't document?
Objection asked and answered.
Sustained.
I have no further questions. Thank you.
Are there
Thank you.
juror questions for Lieutenant Cheney? Lieutenant Shaning, you mentioned that the rapid response officers volunteered for that position, is that right?
That is correct.
Okay, and is there any kind of fitness requirement for that position?
Yes. So generally, as part of the selection process, we do some minimum standard physical tests. They're not extensive. That we have, as their employer, we have certain rules we have to follow around physical fitness. But generally, we check to see if they can run at a certain pace or really just maintain a jog at a certain pace, some push-ups, that sort of stuff.
Okay, and can you speak, if you know, to whether or not at PPB training addresses, actually, I guess I don't exactly know what this question is getting at. Is there any psychological support given to officers as part of their employment with PPB, as part of their training or through another route?
That's a great question. Not so much in the training. We do at times in a training environment talk about the resources available to officers. Typical resources that be available by any large employer is probably going to offer some sort of employee assistance program. We offer the same things. So in the context of, I guess, this conversation, there are those resources available continuously for our members. We highlighted those resources over the course of 2021. And then following the summer of 2020, we offered extensive resources to our members, recognizing the trauma they'd been through and the fact they were going from that work assignment back to patrol. And there needed to be some time to kind of decompress, talk about what they'd experienced before they went back into a patrol setting.
Does use of force training with PPB have any component that addresses, I guess, psychological factors that might influence an officer's decision-making, like emotional reactivity, anything like that?
It's a little bit tougher question to answer. We do talk about decision-making, how you make decisions. And I think to the extent that we, I say train people, but in our, how we train people, how to deal with people, the subject of a call, a police call, the types of resources that you would utilize, the way you would do it. We talked about the warnings, that sort of stuff. All of it is designed to, when possible, I guess, increase the amount of time that an officer or officers have before they have to make a decision to use force. And I guess that would address sort of that reactionary piece when possible. More time gives you more options and decreases the likelihood of having to use force. So to the extent that that would address the psychological piece, I would say yes.
You touched on this a little bit in your testimony, but can you just sort of recap what attempt the Portland Police Bureau made to identify or obtain more information about the specific use of force described by Mrs. Wenzel, so that the allegations in this case?
Okay. So my role as the organizational deponent was, it was structured, it was somewhat limited in what I could do. There are rules around investigations, rules around those sorts of things when it comes to a complaint of force, excessive force. Members have due process rights that we have to respect. So the extent of my role was to review the use of force reports that were available from August 14th, 2020. So to the extent that I did that, I looked at what I knew of Mrs. Wenzel's allegations at the time. I reviewed the force data collection reports that were available to me from August 14th, 2020, and I tried to match those in some way, look at the descriptions of force that were used, the description of the force, the person that force was used on, what I knew of Ms. Wenzel's allegations, and I simply couldn't, based on that information, conclude that any specific incident of force was the one Ms. Wenzel was describing. You heard questions about, did I show pictures to officers? Did I interview officers? And really, it's not appropriate for me in that role to do that. If there was an allegation of excessive force, the independent police review would investigate that. They would interview officers that were named in that complaint, and those officers would have due process rights. And I simply, it wouldn't be appropriate for me to do those things in my role.
Mr. Burgess, do you have follow-up questions based on the juror questions?
Yeah, sorry. Sorry, I thought there were 4 questions, so that's why I was. With respect to question number 2, do officers that when the RRT was a unit or force, did the officers receive any kind of psychological or training as to how to psychologically assess the motives of people in a crowd?
I don't know if I understand your question. Psychologically assess.
Well, assess the intentions of the crowd. That's what I sort of understood from the question, and I was trying to. Did they receive training about that kind of feature of crowd control?
So again, we're going outside the scope of August 14th, 2020.
I think since it concerns training, it would have to. I assume you didn't do any training on August 14, 2020 that you're aware of?
We did not.
Okay, so if we're talking about training, it's got to be broader than that.
So into trying to interpret the intent of people.
Right, is that something you train people about?
Your Honor, I understand the court's ruling. I thought this was.
Okay, I'm going to sustain the objection to this question.
Understood. Do you know, outside of your role as a corporate deponent, if there was anything else done to ascertain who was the officer involved in the use of force against Ms. Wenzel?
I don't have any information one way or the other.
Okay. You said something about the names of the officers. You wouldn't need, if you were attacked by an officer, you wouldn't need to have the officer's name in order to file such a report, right?
No, absolutely not.
Right. And in order to initiate some kind of review of the use of force through any mechanism, whether it's through civilian complaint or internally from an officer or anywhere else, you don't need to know the name of the officer, right?
No, we accept allegations of misconduct, including unnamed officers.
Okay. And so when somebody sues the city of Portland for excessive force by an officer, does that trigger any kind of review by the Portland Police Bureau, to your knowledge?
I believe generally, yes, a tort claim filed against the city of Portland with an allegation of excessive force or misconduct would normally initiate an investigation.
Okay, but you didn't rely on any such investigation to try and figure out who attacked Ms. Wenzel, did you?
So again, I don't have access to investigations about allegations of misconduct. And for generally speaking, my experience is when a tort claim is filed and the investigation is initiated, normally they cannot be completed until the suit is resolved, because frequently the plaintiffs don't cooperate with those investigations.
Okay, but so you may not have that authority, but the city of Portland does, doesn't it?
To investigate those?
Right.
Yes.
Oh. I don't have any other questions. Thank you.
Lieutenant Shaning, if certainly wouldn't you agree that if the complainant was able to identify an officer, that would help any subsequent investigation?
Yes.
And you said you reviewed the complaint in this case, correct?
Yes.
And Ms. Wenzel's complaint.
Objection was excluded.
Sustained.
It's your understanding that throughout these proceedings, no party has been able to identify the two officers involved in Ms. Wenzel's uses of force, correct?
That is my understanding.
Your Honor. Sorry, Bill, I didn't mean to.
Do you know personally whether Ms. Wenzel filed a tort claim notice?
I have no information one way or the other.
Do you know
I'm sorry, a tort claim notice?
tort claim notice?
I guess I would assume yes, since we're sitting here today.
Okay. Do you know whether or not she filed a complaint with the Independent Police Review Division of the City Auditor's Office?
I don't know one way or the other.
I understand your testimony that if she had done so, that is one of the typical ways that complaints and allegations of excessive force are investigated by the City of Portland?
Yes.
Nothing further.
Your Honor, can I have one follow-up question?
You need to come tell me what it is with.
Oh.
You're done with your testimony. You can go ahead and step down. Thank you.
Your Honor.
Plaintiff rests, Your Honor.
All right. Thank you very much for letting us know that, Mr. Burgess. At this point, since we're so close to lunch, it doesn't make a lot of sense to start with a new witness. What I'd like to do is send you to lunch now. Thank you for your service this morning. Please be back in the jury room by 1:10. I have the honor of marrying some people right at the end of lunch, and I think we'll probably be able to start around 1:15 or a little bit after, but that's what's going on here in the courtroom when you're not here. Thank you.
Okay. Yeah. So. It looks like I'll probably be starting up the stream again just a little bit after 1 o'clock.
Motions. Plaintiff moves to amend the complaint to conform with the evidence that's been presented so far. And I wanted to make that motion to begin with before we move on.
How?
Well, so I believe that the evidence that's been presented at trial would be consistent with, I think the court's orders at pretrial or before trial essentially constrained plaintiff's negligence action to only be concerning a failure to train. Am I not speaking loudly enough? Sorry. That it only involved a failure to train or supervise or discipline. And I think that the evidence that's been presented so far would be sufficient for simply a negligence action in terms of the conduct of the officer.
So that was not a ruling I made. That is what your complaint says.
I understand that.
Okay.
That's why I'm moving to amend at this point.
Okay, to just negligence in that, so that the allegation would be negligence of the officers on the night of August 14th?
Correct.
Okay, are you seeking to withdraw the portion of your negligence claim relating to training or discipline? And do you have any evidence in the record as it stands now of failure to discipline?
No, I don't. So I guess the answer to your question would be yes.
Okay. So failure to train is still part of your case, and you're now seeking to amend to, I guess, broaden the negligence claim to the actions of the officers involved on August 14th.
Yes, Your Honor. Thank
Does
you.
the city have a position on that motion?
Yes, Your Honor, the city would object to amending to conform to the evidence. This isn't simply just the amendment of the wage loss, for instance, which has already been done, but this is substantially changing the negligence claim, I mean, qualitatively changing. So it is not appropriate at this stage to essentially add a completely new claim. Negligence is not a lesser included of an intentional tort. These are separate actions. He's alleged that this was done very intentionally, and frankly, I don't see any evidence to support the idea that it was a whoops, or I mean, I don't see there being evidence. So I would argue it's prejudicial to the
I
city.
mean,
but
hasn't there
then-
been plenty of evidence from officers explaining that it's never the intent of an officer that somebody fall when pushed under these circumstances?
I think that's different. Plaintiff's theory of the case has been that an officer ran at her and slammed her to the ground. I don't think what the officers have testified to can change her theory of the case.
May I speak?
Yes, but evidence is evidence regardless of who elicited it. Mr. Manlove?
Right, and counsel, her own, Ms. Wenzel testified that the officer, there was testimony about the pushing of the baton in the back and describing, I think counsel asked, did it seem intentional to you? And she was allowed to testify that it felt like it wasn't an accident. It wasn't just somebody bumping into her, like the second use of force, perhaps, for the protester. But this was an intentional shove down to the ground to develop his assault and battery claim. The fact that, other officers dealing with other people, not necessarily intended to take people to the ground. I think their testimony was not necessarily. I mean, sometimes if they were going to affect an arrest, maybe it was to take them to the ground. I think most of the testimony was to get them out of the street, and then sometimes people would fall. It's just because they fell doesn't mean that it turns into a negligent act. That pushing, that decision to use that type of force against that protester, as we saw in Officer Taylor's video, that was clearly an intentional act, an intentional decision. What happened afterwards? I mean, you can't say, the mere fact that the person, perhaps tripped over the curb or went down to the ground. It's the use of force. It's the use of force that's the focus, whether it was done intentionally or accidentally. And you can imagine both situations, but the council hasn't developed that evidence. There isn't any evidence in this case that any officer, when they were using force in any of the videos or any of the testimony, that it wasn't done other than intentionally. It was done with a purpose. The issue in this case is whether it was done excessively, whether it was done reasonably, whether it was necessary to accomplish the official purpose. All the evidence in the case is about the application of intentional uses of force. There isn't any negligence. You know, what happens if someone falls down because of the intentional use of force? That doesn't allow him to amend the complaint and bring in a new specification of negligence. It's a complete misfocus. It's not on what happens to the subject of the force. It's the intent of the actor of the force.
And I would encourage the court to look at paragraph 11 of plaintiff's complaint to review what the city was on notice about as far as what this
Sure.
case would be about.
I
And
do
it's not
find
a
this
simple revision.
whole
to-
argument interesting in the sense that I believe that both sides requested just the standard jury instruction on negligence and didn't particularize it to the actual allegations. So I am not going to rule on this issue. I do, before lunch, and I understand that may impact the directed verdict motion. Mr. Burgess, I do need to hear your specific theory of negligence from August 14th so that I can understand if it's the same factual body as the assault claim and the same factual body as the battery claim.
Yes, thank you, Your Honor. So I think that the testimony of multiple witnesses of officers was that it would never be their intent to cause harm to a person. That wouldn't be their goal. I think that's exactly what Mr. either Kammerer or Taylor indicated in their testimony, and that goes specifically to the issue of intent. So if both sides agree that the uniform civil jury instruction relating to intent requires both an intent to cause harmful or offensive contact, and that it's not simply that you intended to do the action that you committed, but that you intended or knew that it was substantially likely that it would cause harmful or offensive contact. Their testimony from their witnesses is basically, if we shoved her to the ground and hurt her, we were doing it for the purpose of clearing the street and doing some kind of official government purpose. And if so, I anticipate that they will make that argument to the jury that basically our argument is one tick shy of the requisite level of intent to have an assault or battery claim. But a jury could, of course, find that that officer, even if they agreed with the city that the use of force was maybe intended for some other purpose. I mean, I don't agree that that's the truth, but that is what was presented in testimony in this court. And if the jury believed that, they could still believe that and still believe that the officer's actions were negligent. And I think that given the evidence that has been presented at trial, the Oregon Rules of Civil Procedure allow amendment all the way up into trial, and they're supposed to be freely given. The rules allow amendment with, extreme liberality, and I think that given that the jury has heard evidence concerning this subject, that they heard testimony from officers that they don't intend to hurt people, that they intend to use force to accomplish a government purpose, they could find that using the force that was used against Ms. Wenzel was negligent, and therefore it should be one of the claims that goes to the jury. And I agree with Your Honor, they submitted jury instructions, and they also have treated this case as an ordinary negligence case, both in their answer to the plaintiff's complaint, the fact that they requested a comparative fault jury instruction, which only really makes sense if they're suggesting that there was some kind of she was negligent, because she couldn't be comparatively negligent with their failure to train or discipline. The instruction barely makes sense unless this is seen as an ordinary negligence case.
Your Honor, I don't see what this has to do with jury instructions. We have not decided on jury instructions. The parties have submitted proposed jury instructions. So what the parties have submitted is neither here nor there with this issue. This is an issue about prejudice to the city at a late stage amendment. So let's talk about what would be something from the same set of factual circumstances as the court requested. Yes, if he wanted to say, I want $1 million, I want $10 million, great. That changes nothing about how we have proceeded in the case
Does
thus
that mean
far.
you won't oppose that motion in future cases mid-trial?
The jury's out. That's the same factual basis. We have specifically tailored our presence in this case up to this point to keep certain evidence out, to keep certain evidence in. The jury has heard a version of this case that is centered around negligent training and discipline. That we are not prepared to bring every officer that was there that night to talk about their FDCRs. The text of their FDCRs as to why they used force, what was going on, what was in their head, that's all been excluded. The court said that can't come in. So we would have to bring each and every one of those dozens of officers that use force to talk about, okay, was it negligent? Was it intentional? We're not taking that approach with this case because our goal thus far has been to talk about training and discipline. So again, I would look at paragraph 11 of their complaint. This is a complete shift in their case, and the city is prejudiced by this late stage change. This isn't a monetary change. This is very different.
So as I understood Mr. Burgess, he's not talking about anything other than the same uses of force. He's talking about it as an alternate theory of liability for the same acts that underlie the assault and the battery claim. Is that right, Mr. Burgess?
Yes, Your Honor.
Okay, so I don't think it requires an examination of all of the excluded evidence. I don't think that becomes relevant because we're still talking about those same acts. I would like to hear the motion for directed verdict.
Yes, Your Honor, the city moves under ORCP 60 for a directed verdict on the existing negligence claim. I guess discipline is already aside. So looking towards training, we've heard nothing about what officers are trained to do with a baton. Are they trained to push? Are they trained to jab? When are they trained to use it this way? When are they trained to use it that way? We've heard none of that. We've heard very little testimony that even predates August 14th, 2020. So the city's position is that the jury would not be able to find any issue of material fact with regard to that claim, and a directed verdict is appropriate.
And so is that the extent of the directed verdict motion? I understand that you may want to talk about negligence as it relates to that night, if that becomes a part of the case, but is the city moving against the assault or the battery claims?
No, Your Honor. The city would move against the PTSD medical bills. I don't think that the testimony was sufficient to establish but-for causation on that portion of the claim. The testimony was that Ms. Wenzel could have and probably would have developed PTSD without this incident occurring. So I don't believe that a jury would find an issue of material fact on that portion of the damages.
Okay, and so why would substantial factor not be in play?
I don't think we have multiple tortfeasors.
Okay, Mr. Burgess.
Yeah, so let me, to take the first one, I think there has been testimony from multiple witnesses that they were never told that they couldn't engage in a particular maneuver that we saw video of, which is, and I think that a jury could conclude from observing the disparity between how they say that they're supposed to act and what they actually do in practice suggests that their training is insufficient to prevent them from assaulting people without regard to their safety or their well-being. The exhibits that I previously showed, exhibit 11, 12, and 10, I think show officers engaging in extreme levels of violence, which cannot possibly be what their training is. Mr. Kammerer and Mr. Shaning indicated in their testimony that they did not believe that that level of force would be appropriate if a person was simply standing or simply dispersing in the street, that if without other conduct that would warrant a use of force, that you could not run into them as slam into them as hard as you can with a baton and knock them to the ground. We heard evidence from Ms. Wenzel that that's exactly what happened to her. So given that their testimony is, this is not what our policy is, but that is in fact actually what happened on the night in question, to say nothing of the many other nights in question that aren't in question, that is, with this case, but that in which officers have used the same maneuver over and over again. But the jury didn't hear that. But my point is, the jury could conclude from the disparity between what the officers said was an appropriate use of force and what actually happened, not only to Ms. Wenzel, but the individuals in the exhibits that were shown, that there was a failure of training. It also sounds like they never specifically addressed, according to Mr. Shaning or Mr. Camera, that specific maneuver in terms of whether or not force was appropriately applied to the person at the back of the crowd when a dynamic encountered them. So I think that there's a failure to train claim, but I won't belabor the point. With respect to the PTSD, I believe counsel is mischaracterizing what Dr. Best's testimony was. When I asked Dr. Best, and actually when a juror question more or less re-asked the same question, she said that she could not say, he couldn't tease out the PTSD symptoms and say that any one of them was the only cause, or that one of them was not interrelated with it. In fact, at the beginning of her deposition, when I asked her whether or not the traumatic events, or rather at the beginning of her examination, when I asked her if the traumatic events, at first I asked catalyst and then I rephrased the question. She eventually testified that those traumatic events had to predate the lack of social support and the other elements that led to, in her mind, together to form PTSD, that they couldn't have happened without the initial traumatic events occurring. So I think, and I asked her specifically on the stand whether any of the treatment that she received was unnecessary, relating to her psychiatric care, and she agreed that that wasn't the case. I think that this is, I think Your Honor is correct, that in terms of causation, the attack that is the subject, the attacks that are the subject of this lawsuit were a substantial factor in leading to the damages that are the subject of defendant's motion, and their motion should be denied.
May I reply on the, at least on the training piece? So, as I recall the testimony, counsel would typically, posit this, Miss Wenzel's description of what happened. And then I think the answer was, assuming that testimony was that, would that be warranted? Many of the officers, especially Detective Camera, Lieutenant Shaning this morning, were explaining, these things aren't done in a vacuum. It's context. Context is what's going to determine the appropriateness or the lawfulness or the reasonableness of the use of force. And she has said that, she is in the street. There's a crowd of protesters in front of her. An officer runs, hits her, shoves her from behind, and he runs up above in front of her. So with respect to the training about this, it's contextual, and I don't think the plaintiff has elicited any sort of any evidence from our witnesses. He certainly could have called his own use of force expert. He didn't. To sort of, he's trying to put her in a vacuum, and even her own testimony isn't in a vacuum. And the city is entitled to a directed verdict on this negligent training claim, because there isn't any evidence that the use of force against Ms. Wenzel was from any sort of negligent practice.
I think that as to the negligent training claim and the damages claim for PTSD, that the plaintiff has met the sum evidence standard on this record, require me to deny the directed verdict motion of the city. Can you be back here, I guess by 1:15? I'm hoping to be able to do my wedding somewhere else.
Want me to clean this
No, I
up?
think hopefully we've found another place for that. Okay, I think you're okay.
Your Honor, you haven't decided on the amendment issue, have you?
I haven't.
Okay.
Would you like me to provide any briefing on that or?
No.
No, okay.
Thank you.
Oh wow, they just straight up ended the meeting. Okay, yeah. I hope she has fun officiating that wedding. That's something I'm able to officiate, but I haven't had the chance to just yet. Yeah, that's definitely some interesting stuff going back and forth. A lot of the language that I hear is reminiscent of a Monell claim, which I don't know that those claims have been made in this case, but that's where a lot of this stuff seems to be leading towards, and it feels like it's going to feed into the how important this case is going to be for future protest-related use of force cases in the future. Yeah, as far as their plan, it sounds like the judge is probably at like 1 o'clock has that wedding that she's officiating. Then they're going to be back in the courtroom at 1:15. Probably try to sort out some more of this these motion things without the jury, and then it sounds like hoping by like 1:30 they'll be able to bring the jury back in and start up. Yesterday, court went until about 5 p.m. So I kind of anticipate 4:30, 5 o'clock, depending on how long the next witnesses are. And it's also weekend, so people wanting to get out of there and totally get. That said, I'm gonna go ahead and keep an eye out and have try to be ready to go a little bit after 1 o'clock. I definitely thank everyone for tuning in and joining us here while we see all this stuff. If you aren't already subscribed or following, because we got all the different platforms, feel free to click the appropriate buttons. Share the information out to others that you think might be interested. And yeah, we will see y'all when we come back this afternoon.